This is a breaking news alert. Donald Trump's so-called reciprocal tariffs against the world have just been declared unlawful by the United States Court of Appeals for the Federal Circuit in a 7-4 decision. This was a ruling by what's called an en banc panel, meaning all of the judges that comprise the Court of Appeals for the Federal Circuit participated in this ruling. 7 of the judges ruled against Donald Trump, 4 ruled in favor, but that 7-4 vote means that Donald Trump's reciprocal tariffs against the world, as he calls them, are hereby declared unlawful. Now, the court withheld issuing its mandate until October 14th. What that means is that they've given him time to appeal their ruling to the United States Supreme Court. The unlawful tariffs thus remain in effect until October 14th, but we now have that definitive ruling by this Court of Appeals. We've been waiting on that ruling since the Court of International Trade first declared the reciprocal tariffs unlawful. We now have a ruling, though, that these tariffs are hereby declared unlawful. Now, you will recall that Donald Trump tried to invoke a law known as the International Emergency Economic Powers Act, IEEPA. IEEPA, and Trump claimed that there was a national emergency against every single country in the world. Thus, that's why he needed to implement the so-called reciprocal tariffs. In the 7-4 ruling, this Court of Appeals said that the IEEPA does not allow the President of the United States to affirmatively issue tariffs. It provides for sanctioning foreign countries or engaging in other economic reprisals against other countries, but not the power to tariff. I'd like to go through this ruling with you like we do here on the MeidasTouch network, where we do it in a very detailed fashion. It was a 129-page order, right around there. I've read the entire order right now, but I want to go through some of the key points so we can understand this order together, declaring Donald Trump's tariffs against the world, the so-called reciprocal tariffs made via 5 executive orders, are hereby declared unlawful by this Court of Appeals. So let's go through this order together. It says the government appeals, Trump appeals a decision of the Court of International Trade, that was like the trial court, setting aside 5 executive orders that impose tariffs of unlimited duration on nearly all goods from nearly every country in the world, holding that the tariffs were not authorized by the International Emergency Economic Powers Act, IEEPA, 50 U.S.C. Section 1701. Because we agree, meaning the Court of Appeals, we agree that IEEPA's grant of presidential authority to regulate imports does not authorize the tariffs imposed by the executive orders, we affirm. IEEPA does not allow what Trump did via executive order. We hereby affirm the lower court's ruling that these tariffs are unlawful. Then they give until October 15th for Trump to file an appeal before the United States Supreme Court. I want to go through more of the history that they outline in this order, but let's go to the meat of it first, where the court does what's called a statutory interpretation. And here's why they say IEEPA does not give Donald Trump the authority here to do what he did. Let's go to page 26 and 27. The court says, we must first consider the statutory text, including any relevant canons of interpretation. What that means is, how should we interpret the statute here? It goes on to say, IEEPA, that's again the emergency statute that Donald Trump used, authorizes the president to take certain actions in response to a declared national emergency arising from a, quote, unusual and extraordinary threat to the national security, foreign policy, or economy of the United States. Upon the declaration of such an emergency, IEEPA authorizes the president to, now here's what the statute says, here's what the law says, investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of, or dealing in, or exercising any right, power, or privilege with respect to or transactions involving any property in which any foreign country or national thereof has any interest by any person or with respect to any property subject to the jurisdiction of the United States. So pause there before I read the order more. Do you see any language in there that says hereby gives the president the authority to tariff? No, it doesn't say tariff in what I just listed. It does use the word regulate, and that's what the Trump regime was arguing, that because IEEPA uses the word regulate, a regulation is a tariff, they argued, and thus we are declaring an emergency against the world. We're regulating the whole world trade system by tariffing every country in the world. I'm going to read from you more what this Court of Appeal says, but they said, no. Let's do statutory interpretation. Congress, when it has given the president certain powers over tariffs, it's used the word tariff. It doesn't use the word regulate. If the word regulate meant tariff, or any other word that Donald Trump construes the word regulate to mean, regulate would have any number of meanings and Trump could do everything. That can't be the case, essentially, is what the Court of Appeals is saying here. If Congress wanted to give the president power of tariff on an emergency basis, Congress would have used the word tariff. And then it goes on to say that the power of tariffing is a power of Congress, not the presidency. So let me read more from the ruling now. So we use the exact text. It says, the statute bestows significant authority on the president to undertake a number of actions in response to a declared national emergency, but none of these actions explicitly include the power to impose tariffs, duties, or the like, or the power to tax. The government locates that authority within the term regulate importation, but it is far from plain that regulate importation in this context includes the power to impose the tariffs at issue in this case. Notably, when drafting IEEPA, Congress did not use the term tariff or any of its synonyms, like duty or tax. There are numerous statutes that do delegate to the president the power to impose tariffs, but in each of these statutes that we have identified, Congress has used clear and precise terms to delegate tariff power, reciting the term duties or one of its synonyms. In contrast, none of these statutes use the broad term regulate without also separately and explicitly granting the president the authority to impose tariffs. The absence of any such tariff language in IEEPA contrasts with the statutes where Congress has affirmatively granted such power and included clear limits on that power. And that's an important point right there. Clear limits on the power. Where Congress has given certain powers to the presidency to tariff, Congress, because tariffing is the power of Congress, has significantly curtailed that authority within strict limits, strict time frames, strict amounts, not everything. So if Congress was going to use the word tariffs in other statutes and then limit it significantly because Congress, once upon a time before MAGA took it over, would try to safeguard its own constitutional powers, which is the power over tariffs, why would they then just use the word regulate and then render all of their constitutional powers to completely be eliminated? That's basically what they're saying here. Hey everybody, Ben Meiselas here from the MeidasTouch Network. I wanted to let you know about my podcast partner, Michael Popak's new law firm. It's called the Popak Firm. Michael Popak's pursuing his dream of starting his own law firm, really based on the popular demand by all the Meidas, Mighty, and legal AFers who are approaching Michael Popak with their cases and saying, can you help us? And at that time, Popak was not able to. So he went out on his own. He started the Popak Firm, where he is now handling catastrophic injury cases like car accident cases, trucking cases, malpractice cases, big negligence cases, wrongful death cases. So if you or someone you know have a case like this, the consultation with Popak's firm is free. Give him a call. See if you have a case. It's thepopakfirm.com, thepopakfirm.com, or you can call 1-877-POPOK-AF, P-O-P-O-K-A-F. So 1-877-POPOK-AF. Give Michael Popok a call. And I'm really proud of you, Popok. Thanks for all the hard work you're putting in. So as we dig back into page 36 and 37, I think this is important as well. On page 36, it says, additionally, as already discussed, tariffs are a core congressional power. The basic and consequential trade-offs that are inherent in the president's decision to impose the trafficking and reciprocal tariffs are ones that Congress would likely have intended for itself. Moreover, the United States imports more than $4 trillion of goods annually. These imports account for 14% of the nation's economy. The government itself has claimed that reciprocal tariffs will generate between $2.3 trillion and $3.3 trillion over the budget window. The executive's use of tariffs qualifies as a decision of vast economic and political significance, so the government must point to a clear congressional authorization for its determination or its interpretation. For the reasons discussed above, we discern no clear congressional authorization by IEEPA, the Emergency Act, for tariffs of the magnitude of the reciprocal tariffs and trafficking tariffs. Reading the phrase regulate importation to include imposing these tariffs is a wafer-thin reed on which to rest such sweeping powers. Now, if you go through some of the other portions of this ruling as well, it describes what's going on here, that this case involves this is on page 5. The case involves the extent of the president's authority under IEEPA to regulate importation in response to a national emergency declared by the president. For many years, Congress has carefully constructed tariff schedules which provide for, in great detail, the tariffs to be imposed on particular goods. But since taking office, Donald Trump has declared several national emergencies. In response to these declared national emergencies, the president has departed from the established tariff schedules and imposed varying tariffs of unlimited duration on imports of nearly all goods from nearly every country with which the United States conducts trade. This appeal concerns 5 executive orders imposing duties on foreign trade partners to address these emergencies. Then it goes and it summarizes the history of the case, where these small private businesses like VOS Selections, Plastic Service Products, Micro Kits, Fish USA, and Terry Precision, they brought their case first in the Court of International Trade. The Court of International Trade similarly ruled against Donald Trump. They stayed that decision on May 28th, 2025. The case then made its way up to this Circuit Court of Appeals, and the Circuit Court of Appeals made this ruling. And then they make it very clear as well here what the Constitution says. It says, the Constitution grants Congress the power to lay and collect taxes, duties, imposts, and excises, and to regulate commerce with foreign nations. Tariffs are a tax, and the framers of the Constitution expressly contemplated the exclusive grant of taxing power to the legislative branch when Patrick Henry expressed concern that the president may easily become a king. An important line right there, right? James Madison replied that this would not occur because the purse is in the hands of the representatives of the people. Congress is what they say. So the court then makes it clear, look, we're not addressing whether the president's actions should have been taken as a matter of policy, nor are we deciding whether IEEPA authorizes any tariffs at all. We're addressing what Trump did, these reciprocal tariffs in the 5 executive orders. We conclude that the reciprocal tariffs, which is everything that Trump's basically did, that they are not authorized by IEEPA, and they hereby rule against Donald Trump. The headline being, Appeals Court rejects Trump's global tariffs. All right, what happens next? Well, these unlawful tariffs stay on the books until October 14th. Why? Because the court withheld its mandate to allow for an appeal to happen to the United States Supreme Court. You see it right here. The clerk is directed to withhold issuance of the mandate through October 14th during which the parties may file a petition for a writ of certiorari to the Supreme Court. If within that period any party notifies the clerk in writing that it has filed a petition for a writ, the clerk is directed to withhold issuance of the mandate pending the ruling of the Supreme Court's denial of the writ of certiorari or a judgment of the Supreme Court if certiorari is granted. While the issuance of the mandate is withheld, the United States Court of International Trade shall take no further action. In other words, these tariffs are deemed unlawful, but this order doesn't take effect until October 14th. If a party goes to the Supreme Court, in this case the Trump regime, then this order is stayed pending what the Supreme Court rules. But the headline is the Court of Appeals now saying these tariffs are unlawful. So you think about all of the problems that Donald Trump has now created by imposing these unlawful tariffs against the world. We wait for the United States Supreme Court. I know that was probably a more detailed analysis that you'll get other places, but I wanted to go through the text of this 100+ page order. Hit subscribe. Let's get to 6 million subscribers together. Thank you for watching.
Love this video? Support independent media and unlock exclusive content, ad-free videos, and custom emojis by becoming a paid member of our YouTube channel today. You can also gift memberships to others. Let's keep growing together.